take it away. Hey, Jim.
Charlie.
Thanks, Charlie, and happy to be here, excited to be here, both as a Howard alum and also having spent time working with you at Microsoft. So let's kick it off. I can start with some brief introductions. As Charlie mentioned, I'm Stanton Burke. I am an associate at Baker & Hostetler. I counsel clients on a broad range of regulatory matters, including data privacy, data integrity, cybersecurity, and tech transactions. I've also advised clients on Gdpr and CCPA, and as well as products like AI and ethical and legal considerations when deploying them. I also conduct M&A due diligence from a data privacy and data protection perspective. Also on the panel, we have Dominique, Shelton, Leipzig. Dominique co-chairs the Perkins Coie's ad tech privacy and data management practice. She provides strategic privacy and cyber preparedness compliance counseling and defends, counsels, and represents companies on privacy, global data security compliance, data breaches, and investigations with an eye towards helping clients avoid litigation. As a former litigator with 22 years, her compliance counseling over the past 7 years includes defending companies under investigation by the FTC, attorneys general offices, and other regulatory and government authorities. Shannon McNeal, who's also a Howard alum, is an associate at Davis Wright Tremaine. Shannon focuses her practice on technology, privacy, and security matters with a focus on contracts related to marketing, advertising, entertainment, and consumer matters. She regularly assists clients by drafting and negotiating agreements of various kinds for the tech industry. And Shannon also provides counseling related to technology and technology commercialization, including related regulatory matters. Jim Sfekas is a cybersecurity attorney at Microsoft. He is the lead attorney supporting security and compliance products in Microsoft 365. He supports the Microsoft 365 Defender product suite, including Microsoft Defender for Endpoint and Microsoft Defender for Office 365. Jim also manages the team supporting various compliance products. And in addition, Jim supports the Microsoft 365 security research team, as well as the Microsoft Office 365 CISO, Chief Information Security Officer. Ashley Lynn is an associate at Perkins Coie, and she advises clients in a range of legal issues relating to emerging companies and venture capital, including general corporate governance matters, entity formation, venture financing, and as well as buy and sell mergers and acquisitions. She has experience working across many industries, including renewables and high-tech sectors. She also counsels clients on privacy matters, such as the CCPA and the Gdpr. All right, as you can see, we have a lot of experience on this panel, and without further ado, I'd like to kick it off. Today, we'll start with Jim, who's going to give us an overview of AI and ML technology, and then we'll pass it to Shannon, who will give us some details on the laws impacting AI and ML and cybersecurity. And then Dominique will talk us through the future landscape, including some of these AI responsible principles that Microsoft has in place and that many companies have in place. And then, as time permits, we'll just kick it off with a discussion and talk a little bit more about our careers in data privacy. All right, Jim. So we often hear about AI and machine learning thrown around as buzzwords, but can you tell us more about what these terms actually mean and how they implicate cybersecurity considerations?
Thanks, Stanton. Absolutely. And I'll say we one of the joys of coming so soon after my friends Caduce and Colin is that I get to skip over some of these fundamentals because you've already gotten an even deeper dive on how all of this works. I'll just note on this slide that machine learning is the primary focus for where the efforts in AI really develop in the cybersecurity space. As I talk through this, I'm going to use the antivirus, the Windows Defender antivirus, as an example of both what we do and why we do it with machine learning in this space. So on to the next slide, please. So drawing from the experience of Defender, in a single day, we had just a random single day, Defender AV sees 2.6 million people across 232 countries and regions experience 1.7 million first seen attacks, meaning malware, things like that have never been seen in the wild before. Next slide, please. 60% of those attacks were over within the hour. Next slide. And the lesson from that and the point of those numbers is to emphasize human defenders aren't enough to protect us from modern threats. There aren't enough security professionals that we could hire to keep up with that volume, and human response time just isn't fast enough to keep up with the rate of new attacks. If we were relying just on human analysts to find these first seen attacks, by the time we were able to ship out a new signature to block it, the attack would be over and we would have failed in our mission. Most of these attacks are commoditized, which means built from known patterns and techniques. And that's where machine learning gives us the leverage to meet the scale of those attacks. We have the human defenders build the models, investigate the novel techniques, and then monitor for the ongoing really major threats. And in the meantime, using the machine learning to figure out how to block those commoditized attacks. Next slide. So I know that you got a great deep dive on this in the last session, so I'll just do a quick reminder of the stages of machine learning. In the initial development stage, we have the process of training the machine learning model using training data that is some form of the corpus of data that we already want have information about classification, and then at the inference stage is when we deploy and feed in the real life data that we want the product to work from. And obviously we depend on a feedback loop to continuously update the models as time goes on. Thank you. Next slide. And just one quick reminder, in the cybersecurity space, both supervised and unsupervised models are something we rely on. In the supervised case, it is looking for our cases where our human analysts have identified particular malware or clean, and feed both of those things into the model to teach it how to recognize new malware. On the other side, on the unsupervised side, we're just looking for those patterns and the groupings that can help us understand classifications. And I can tell you, in the security space, we did a survey recently, and we have something like 100 models deployed across our various security products. So that's the motivation for this from the cybersecurity perspective, and we'll come back later to talk about how this shows up. Back to you, Stanton. Thanks.
Thanks, Jim. And I've always heard the phrase, when it comes to cybersecurity, it's not if but when. And so you're always having to be on, not just on the defense, but on the attack. And so kind of seeking out some of these new forms of attacks with both supervised and unsupervised learning is critical to businesses. So thank you for that overview. Shannon, now that we know what AI machine learning is and how it applies in this context, can you tell us more about the laws that are implicated by these technologies?
Yeah, would love to. Hi, everybody, and a special hello to my Hustle family. It's really great to be here with you all today. To answer the question, these technologies are subject to a host of data privacy laws that regulate how data is used in connection with machine learning techniques, and also laws that prescribe requirements to safeguard and secure this data. So here in the United States, Section 5 of the FTC Act prohibits unfair or deceptive acts or practices in the marketplace. And that tool had been really key in privacy regulation. Otherwise, privacy laws had been sort of limited to specific sectors. So if you think of HIPAA or you think of a very specific data type, CAPA comes into play in protecting children's online privacy. But the definition of personal information was pretty limited under that circumstance. And there wasn't a whole lot of consumer control of data. In terms of state activity, it had largely been focused on data breach notifications with limited enforcement. But we're having this conversation here today because states have started to establish general privacy and specific privacy laws that, of course, have implications for AI and machine learning. But before getting to the CCPA and the CPRA, I think we have to acknowledge its muse, the General Data Protection Regulation, aka GDPR. And I'm sure many of you remember GDPR. It set your inbox on fire early 2018 with all of those updates and notifications. But GDPR is the EU's comprehensive data protection framework. And it does have important implications for AI and machine learning, including, so Article 5 captures the principle of data minimization, which basically means that, you know, don't process or store more than what's necessary in order to process the data. And then there's Article 32, which requires security measures appropriate to the risk to ensure ongoing confidentiality, integrity, availability, resilience of processing systems and services. And actually, let's go ahead and go to the next slide here, because we're just going to go right into the CCPA. So California now has its own comprehensive data protection law, the California Consumer Privacy Act, or the CCPA, which was recently amended by the passage of the California Privacy Rights Act, or the CPRA. Now, Dominique will discuss the private right of action available in this framework, but I'm going to give an overview of our two California friends. So generally speaking, and for the sake of time, the CCPA applies to companies that do business in California and collect personal information from California residents. And a lot of those terms have specific meanings, but just for the sake of time, that's sort of the general framework there. And the definition of personal information under the CCPA is incredibly broad, and it includes things such as phone numbers and social security numbers, biometric information, IP addresses. And so here on this lovely chart here, we have some of the rights and obligations that the CCPA provides. And the first three, and maybe even number 6, I would say, concern this Joe, I want to know, right to know, right? About what personal information a business collects about consumers and how it's used and how it's shared. So in general, right, you have a right to know, and you can ask for categories of information that have been collected about consumers. But you also have a more detailed or specific right to know specific information, such as the source of the personal information that's collected. You can ask for the business purpose for collecting and sharing personal information, the categories of third parties, and specific pieces of information, so specific elements about you as a consumer. And that sort of relates to the next several rights, right? So the right to disclose categories of information sold. You can ask for an itemized list of categories regarding what's collected, what's sold, and what's disclosed to a third party about the consumer, about you specifically for a business purpose. Then there's also the right to opt out of the sale of personal information. You're probably familiar with seeing these hyperlinks at the bottom of web pages that basically say, do not sell my personal information, and it links to an opt-out page. And so that's what we're talking about here. And not all companies have them, because not all companies take the position that they sell data. And that could take you down a whole nother rabbit hole that we don't even have time for today. Then there's also the right to opt in to the sale of personal information with respect to kids. In order to sell personal information of children under the age of 16, businesses need to acquire their opt-in consent. And if you're under 13, you would need, if you're under 13, you would need parental guardian consent as well. Then we have this right to access and portability, very related to what we've discussed earlier. You have a right to the disclosure of categories and specific pieces of information that a business has collected about you. And if it's electronic, if it's available electronically, the business, the information should be portable and in a readily usable format that allows a consumer to transmit the information without hindrance. You also have the right to delete. You can ask a business to delete personal information collected about you. And then there is this right to not be discriminated against for asserting the rights that we've discussed, right? So discrimination in this context could mean a number of things. It could be denying goods or services to the consumer. It could be charging different prices. It could be varying the level or quality of those goods or services, suggesting that that consumer would receive a different price, so on and so forth. You get the idea. And so that is a layout of the CCPA. And if I could have the next slide, we can talk about the CPRA, right? So I'm not going to peg this one-to-one with the prior slide because this slide does such a good job of that. But there are a couple of really interesting additional rights that the CPRA provides on top of the CCPA. So one would be the right to correct information, right? So now a consumer can ask a business to correct information that is inaccurate, and businesses have to disclose this new right in a commercially reasonable way, right? You basically have to have the ability and the mechanism to ask for the right to correct information. Then there is this right to limit sensitive personal information. And here, sensitive information is sort of the newbie to the equation. This term includes 20 different data points, which include, for example, racial origin, religious beliefs, sexual orientation, and geolocation. So consumers can limit the use and disclosure of sensitive information to what's necessary to perform the services or provide goods reasonably expected by the consumer, so on and so forth. So for example, a consumer could say, could prevent the business from disclosing this kind of information to third parties. And this might not mean much to law students in the room, but to practitioners, I'm sure you could appreciate like how onerous this overlay, right? It's not completely different than the CCPA, but it just makes it a little bit more complex to comply if you haven't already had a very thorough apparatus to do so previously. If you've already been capturing data in a way that didn't really account for this sensitive personal information category. Then there's the right to access information about automated decision-making, which, as you might imagine, has some implications for what we're discussing here today. So customers can ask or may request information about the logic involved in automated decision-making and a description of the likely outcome of those processes. So that's really important for anybody going into sort of an AI or machine learning process or practice. Then there is the expanded right to know. So for information collected on or after January 1st, 2022, the CPRA, allows a consumer to make a request to know beyond that normal 12-month look-back period, as long as doing so isn't impossible or doesn't involve a disproportionate effort. So to companies who sort of retain data for long periods of time, I suppose. I mean, generally a good data governance practice probably wouldn't allow you to keep data for too much longer than needed, but to the extent that you're holding on to it and it's not impossible to retrieve and to explain or provide information about to the consumer, you now have that obligation. Then there is the expanded right to opt out, which, again, very similar to the prior right provided by the CCPA, except this time the right to opt out now includes sharing in addition to the sale of data. And so I suspect that was an attempt to remedy what was a pretty, I'm not going to say loophole, but many companies take the position that they're not selling data, but they're merely sharing it or transferring it, for a host of reasons, which could include cross-context behavioral advertising. And so now this right basically closes that loophole, whether or not the sharing is done for monetary value or other value. So in addition to the right to know about automated decision-making, there's now this right to opt out of such decision-making, which again could be like pretty complex for practitioners and has important implications for AI, of course. So strengthened rights for minors. So now not only can they opt out, but a business has to wait 12 months before asking the minor to consent to sell or share the data again after the minor declined to provide it. Expanded right of portability. A consumer can now ask a business that the business transmit the personal information from one entity to another to the extent that it's feasible. And then there is this modified right to delete. Businesses that receive a consumer deletion request are required to notify third parties who bought or received the consumer's information, subject to some exceptions. And I'm going a little bit over, so I'm going to wrap this up. There are no security requirements under CCPA and CPRA, though the security requirements of Gdpr serve as a really good guide. And so I'm gonna wrap this up and kick this back to Stanton.
Thanks, Shannon. That was super helpful. And as you can see, everyone, this is an evolving landscape. In fact, just yesterday, Virginia passed a comprehensive privacy law called the Cdpa, which goes into effect on January 1, 2023, which is also worth checking out. Also, and just to tie it back to the broader, to Jim's point, how these laws can intersect with cybersecurity is if, for example, there's personal information that's accessed or exfiltrated by an unauthorized party, that could constitute a breach or a violation of these various privacy laws that Shannon just walked us through. And similarly, a lot of AI and machine learning models use personal information. And so, if you're a company looking to deploy these technologies, you'll want to ensure that you have the proper rights to use your data for this purpose, and that you're in compliance with these laws in terms of providing the right notice and getting the right consent. And just to get on my soapbox a little longer, actually a few months ago, the FTC found that a mobile app, I think EverAlbum, did not have the proper notice and consent to retain facial images that were uploaded to the app, and they allegedly kept this data after people deleted their account and ended up building their own facial recognition software, which they sold to various companies, law enforcement. Well, the FTC not only required them to delete those images, but also said that this facial recognition software that you developed essentially had to be destroyed. You could no longer use it. So very far-reaching implications potentially with this decision, this settlement. And so it's obviously a very ever-changing landscape. And with that, I'll pass it over to Dominique so she can tell us more about this litigation landscape under CCPA and CPRA.
Hi, everyone. So yeah, it has been a whirlwind. I'm talking to you from Los Angeles. We have over 100 cases that have been filed, most of them putative class actions, alleging, all manner of things. The CCPA is only supposed to have a private right of action for negligent data breach. That has not stopped the plaintiff's bar from bringing cases really around the whole statute. So it's very interesting. There's some cases I put here up, some logos here on the slide, and it's to talk about some of these cases that went beyond negligent data breach. So Zoom, for example, they're claiming that the single sign-on that is used for Zoom signing on through Gmail or other platforms, that constitutes unauthorized sharing of personal information, and they're trying to squeeze it into the definition of data breach, which is what's supposed to trigger the private right of action under our Civil Code section 1798.150. And the AG is only supposed to be able to assert claims around things like inadequacy of notice or sharing that's not disclosed, and that's under 1798.155. The first data breach settlement case was for $400,000. It's a case that our firm handled. And there's actually a really interesting case that just came down a couple weeks ago, where a claim against Google, which was related to cookies and tracking, and again, outside of the scope of what the CCPA private right of action is supposed to cover, that got dismissed by one court. So we're going to just see what happens. But TikTok, Zoom, Walmart have all been sued based on sort of behavioral tracking things. So we can go to the next slide. Technically, their plaintiffs are only supposed to, as I said, be able to sue for negligent data breach. The fines are $100 to $750 per violation, and the legislature takes the position that every single record constitutes a separate violation. So it's not just each person. So you can see how this could really add up very quickly. So I put a number here. If you had 10,000 California residents, you would have 7.5 in exposure. But I'll give you another more mind-blowing number. We looked at the 2016 data breach report that was done by the California AG when VP Kamala Harris was our state attorney general. And if those data breaches, there were 375 million, that if those had been 375 million records were involved, we would have had exposure of up to 3.75 billion. And then the AG also has the opportunity to bring cases at $1,000 to $7,500 per violation. So there you go. Next slide. So I just wanted to take a moment to talk about the future state, or where I see things going. And I think it's so pertinent to the discussion we're going to have about career. But I am seeing on the horizon, and I was just talking about this at a Horizons conference for Walmart. I just did a keynote for Motorola Solutions last month where I brought this up. But I just think we're going to continue to see a collision of convergence of technology, social justice, bias, and societal issues like the ones that Liddell was talking to you about as it relates to COVID-19 and other infectious diseases. So the use of AI and the implications of the inadequacies sometimes that can arise if the wrong or players that don't have principles like Microsoft's AI principles, and this would be a good time to turn to that slide. If they get a hold of data and start using it without the same sort of responsibility. And so I'll talk about this a little bit. You know, I am so impressed with what Microsoft has done in terms of developing ethics and as sort of the table stakes for the use of AI. And I just want to point out this, first principle, which is fairness. We have situations, one of our partners in our New York office is on the board of the Lawyers Committee of Civil Rights, Dennis Hopkins, and he sent me a letter that that organization sent to our California State Bar, because as students were trying to take the bar this summer in the middle of COVID-19 and the pandemic, facial recognition was used to unlock the screen so that the examinees could take the exam. And do you imagine how disconcerting it must have been for those students, tense to take the bar, and they can't even open the screen because the facial recognition does not recognize darker skin. And they, unfortunately, whatever facial recognition they were using, it wasn't Microsoft's. And the fairness thing, was not addressed. So I just want to, there's everything else here on the slide, I think goes without saying, reliability, inclusiveness, privacy and security, accountability, right? But fairness and accountability, I think, are really the two prongs that I think that more diverse professionals in the field and those that are allies and sponsors can help, bubble these issues up, because it's not so much an issue of where the law is, but what the company wants to be known for. what do you want splashed across, you know, the New York Times, the Wall Street Journal, the Financial Times with your brand? And I think there's so much that we can talk about here when we get into career. Let me turn it back to Stanton at this point.
Thank you, Dominique. That's spot on, and I agree. You know, in the absence of kind of this comprehensive law governing the development of AI, companies like Microsoft are starting to develop their own principles and rules and practices designed to address these ethical issues and just be responsible. And you know, these principles are really facilitating the development of AI in an ethical and transparent way, using this human-centered approach. I think, Jim, you can probably tell us more about how you see this come into play at Microsoft. I think we lost the slides, but Jim, are you still on? I think you're on mute. That's the famous quote of 2020. I think you're on mute.
There we go. It took Teams a second to get me off of mute. So I experience a lot of these things at a practical level every single day. You know, I talked in the beginning about how essential ML is to cybersecurity. So to make this really concrete, I'm going to talk about it in terms of two products that I'm responsible for. One is email filtering, spam and phishing, which is something that people tend to be familiar with. And then another is endpoint protection. Endpoint protection is a broad category that includes antivirus, but in the enterprise, it's also a broad type of monitoring that looks at activity on individual devices to detect signs that a bad actor has broken in and is still active. In both cases, we're faced with adversaries who are highly motivated to attack and to bypass our machine learning protections. So we rely on constantly improving both supervised and unsupervised ML to be effective in detecting these attacks. And in many cases, you may have seen a most recent example of where this kind of attack comes into play is the over the Christmas time, the attacks from Russian state actor using the SolarWinds software as their initial vector. But the sophistication of these attacks means that to be effective with our machine learning, we're going to need human review of data for grading. And so it's a constant consideration for us how to train our models in a way that our customers would be comfortable with, and at the same time be consistent with privacy laws like CPRA. So the first answer is actually a philosophical one, or arguably an ethical one, which is we focus on trust. Customers are entrusting us with their data, so we have a responsibility to respect that trust. Any company is going to have a number of different driving imperatives, but focusing on the trust narrative gives us a framework for thinking about those imperatives and balancing the different business considerations. In particular, though, customers are trusting us to provide both top-tier security and to be sensitive to the customer expectations on data handling. So that is, they're expecting us to optimize for both security and privacy, even though this is a case where there's a certain amount of tension of security needing more data and privacy pushing us towards having less data. So in terms of how we execute on that trust narrative, a core focus is that we want customers to be able to understand and feel in control of what we're doing. So we do that through strong documentation of what we do and why we do it, and controls that go along with it, so that the customer is making choices on what's happening. Now, certain features are built into what you're paying for, and you can't turn off. But in other cases, we're giving the customer the choice to make for what's right for their specific organization or individual needs. Beyond that, we've actually been investing significantly in technical measures to protect privacy. In many cases, we're doing this through obfuscating personal data rather than having the analyst be able to see the individual identifiers. We see a transformed version that's just a number, because in many cases we don't need to know the individual identifier. We're exploring a number of options for what we're calling eyes-off training, looking for proxies rather than directly classifying the data with the human analysts. And a really interesting area that we're just starting to explore is called homomorphic encryption, which basically allows, it's designed so that any processing can be done on the encrypted version, and you'll get the same result as if you ran that same processing on the unencrypted version. So that lets us work always with encrypted data in certain contexts. Profiling is a particular area that we're always thinking about. Customers rightly are concerned about the idea that big companies like Microsoft are building profiles, and we address that with even more control and in many cases the core profiling functionality that we think customers might be worried about, we have off by default. We have the ability to turn on only when you want it, and with a lot of configuration options. And then finally, the responsible AI principles that Dominique and Stanton were talking about give us an ethical framework that we understand in advance. And so, ethical guidance that lets us avoid ad hoc decision making in the moment. As soon as we move to ad hoc decision making, we know that we become more arbitrary and risk being inconsistent. And so, the responsible AI principles and the review process that we're instituting to go along with it help us make sure that we're meeting our own corporate principles. So. Back to you, Stanton.
Thanks, Jen. That's awesome. And one thing stood out to me. You talked about kind of the balancing of cybersecurity and AI with these important privacy principles like data minimization and purpose limitation. Because often you think, well, the more data, often that's how much the better the algorithm will work. But privacy is saying, do this, and developers and technical teams often say, well, we need to do this. So these privacy principles and frameworks help companies think through how they can store it safely. How do we anonymize it? What's the potential liability of having so much data, and the cost of storing it? So it's definitely a balancing act that I think you've mentioned Microsoft has done a great job of putting in the framework to do so.
An interesting aspect to that is that in the run up to GDPR, we actually overshot in the other direction and went so strong on privacy and data minimization that we realized we actually made it harder for us to protect ourselves, and we're in the process of figuring out the correction to find that sort of optimized state in between.
It's good growing pains, I think, that all of us have to go through. Awesome. So now that we've given everyone an overview of the legal and ethical landscape surrounding AI and ML, let's talk to the panelists about what it's like to work at the forefront of these issues and how they got involved in the field. To help facilitate this discussion, I will hand things over to Ashley, who is an associate at Perkins Coie and works closely with Dominique and is building her career as a privacy attorney. So Ashley, you can do the honors. What made you choose data privacy, and what advice and resources would you recommend to students interested in the space?
Yeah, thanks, Stanton, and thanks for the great intro in the beginning. Hi, everyone. I'm Ashley, and I wasn't on the first slide because I've been kind of in the background manning the slides, and so it's great to see everybody. I am an associate at Perkins Coie. I've been an attorney for about 5 years now, graduated from Berkeley Law in 2016. And my advice to law students is to just really pay attention to what's piquing your interests as you go along in your career and you do different things. So I was a legal assistant before law school at Google and worked in sort of a data privacy area, responding to law enforcement requests for user data under ECPA. And so we would get subpoenas and search warrants and have to parse those and decide what can we give to what legal process. And so it was a super interesting field. Then when I graduated law school, I went to Perkins and did corporate law for startups starting out, and did that for about a year and a half. Then tried out a different practice at a smaller law firm doing renewable energy transactions. And then I decided, you know, my interest really is still in tech. So I came back to Perkins. And throughout all of those changes, I did a lot of self-reflection as to what was the most interesting to me, what got me the most excited, and just thinking back to my work on ECBA and with tech, and how much of the tech you really need to know to understand privacy issues, I realized that is really where my passion lies. And so in coming back to Perkins, I've focused on privacy and now am going full force and building my privacy career. So my general advice is just to kind of pay attention to what you're interested in, and kind of pay attention to what you thought you were interested in and decide, okay, I'm not interested in that anymore, and cross that off. So it's a lot of self-reflection as you go through your career. And panels like this can really help you inform your decisions and decide, oh, that sounds really interesting to me. I might want to explore that, and just give it a try and see where it goes. For folks that are getting into privacy, one really good resource I would recommend is the IAPP. That's the International Association of Privacy Professionals. And so that is a great resource, online resource that you can sign up for. It'll give you all the latest news on privacy, and that we all know the privacy landscape is changing so fast. And so just keeping abreast of those developments is really great. And they also offer certifications, and you can get a certification for US privacy law or for EU privacy law, and that's a really great way to get an overview of the privacy legal landscape and distinguish yourself with that branding once you get that certification. So for folks that are interested in getting into privacy and showing that you have some level of knowledge there, the IAPP certification is a great way to go, and to just get that general overview. So,
awesome. Thanks.
Yeah, so thanks, Stanton. And, you know, now I think we're just going to kind of talk to our other panelists as well, so that we can get an idea of how their careers were going. And I know that Jim has to take off pretty soon. So, Jim, I wanted to start with you. I know you spent some time as a consultant and a software engineer, and as well as a patent attorney. So, you know, speaking of all the things you can do in a long career. So how did you find your passion in data protection and cybersecurity? And, you know, how do you leverage your background in your career today?
Oh, thanks, Ashley. I love, especially when I talk with law students, especially, I like to remind them, you know, and you know, my career as being an example of this, that nothing is set in stone anywhere along the way. You know, I started out my career in engineering, and you know, decided along the way, boy, I think this law thing could be interesting. But if you show up at law school with an electrical engineering degree, you will be sent to be a patent lawyer. And I actually ended up at Perkins as a patent lawyer for a number of years, which was a great development spot. You know, if you want to be a tech lawyer, there's lots of paths, and one you know, coming in through patents worked out super well for me. I only switched into my current role after coming to Microsoft. I joined Microsoft as a patent lawyer and moved roles about a year and a half in, became what we call a product lawyer, which is sort of the front line, thinking about all of the things. But in 2014, thinking about all of the things for products, for product development, meant learning about privacy. And I also did the CIPP back then when I started supporting Windows for Education, and realized how important that was going to be to understand privacy law in general. Somewhere along the way, someone said, "Hey Jim, we need someone to support our security products, and I'd like you to do that. Okay, sure. And so, you know, I was looking to try something different, and they put that in front of me. My manager said, "This is what I want you to do," and you know, it turned out that that was the thing that I went to law school to do. I didn't know it existed. I didn't know this was an option to me, but here I was, you know, a good 10 years, you know, 9 or 10 years out of law school, all of a sudden doing the thing that I could walk in, I could go into work, and I could say, this is what I was looking for all along, and I never even realized it. So to a great extent, and when I have to highlight, I was 40 when I took on that role. So you know, it's never too late, and you know, it's always the progression. But every step of the way, I learned something about industry, about the law. It turns out that being a patent lawyer gets you really good at reading language for contracts too. You know, there's no skill that was wasted, and that was the biggest lesson for me.
That's great. Thanks, Jim. Yeah, and so, you know, going off of this theme now, or maybe this is just how life is, of kind of winding your way through your legal career. You know, Stanton, I also know that you spent time in law school working on environmental law, telecommunications law, and then, you know, you made your way into the policy tech team of 2 major tech companies. So what about you? Like, how did you ultimately land in data protection law, and, you know, what advice would you give to law students?
I would say, you know, trust the path, and, you know, accept the best opportunities that come your way. And for me, I worked at a tech company for 2.5 years before law school, and I went into law school not knowing what area I wanted to practice. As you mentioned, I worked in environmental law, worked in energy law, and actually missed kind of this intersection of technology. And so I started looking for areas where I could kind of merge law and tech. And I you know, ended up working for the FCC for Commissioner Clyburn. And that was where I kind of cut my teeth on the beginning stages of the intersection and learning how about kind of how the policy sector works. From there, I spent my 3rd year of law school at Facebook as a policy associate, where I handled my first mock data incident. I helped write the fact pattern. I also looked into, you know, trying to make it as scary as possible. And I was like, this is it for me. I love that I can merge business with comms, with law, and put it all in one. And so from there, I looked into getting my SIP certifications. I spent my first year out of law school as a fellow on Microsoft's policy team in DC, and that's where I met Charlie and got to really, you know, learn everything, not just about you know, cybersecurity and data privacy, but the intersection of law and policy with all areas of tech, whether that's telecom, whether that's trade, you know, IP, and it really just helped me kind of solidify my career in the space. And from there, I knew I wanted to go to a law firm. I knew I wanted to do big law. So I took a year and went to New York and worked for an intellectual property law firm, and earned my LLM in technology at Cornell Tech. And from there, I joined a law firm where I've been, and then switched over to Baker Hostetler, doing data privacy and cybersecurity full time. And so I think one thing I'd say for students interested is just continue to network, continue to ask a lot of questions, and always be a lifelong learner, and kind of accept the opportunities that come with open arms. And I'm sure you'll find the path that you're interested in. Because looking back, when it didn't really make sense which path I was going to at the time, now I couldn't imagine not being able to leverage those experiences to, you know, advise and counsel clients.
Yeah, thanks, Stanton. And I think one aspect of privacy law that it seems like leverages both you and Jim's prior technical, or, you know, legal background in more technical fields as well, is that this privacy field really requires you to really understand the technology that you're advising on. And I think that's something that is what I really like about this practice, is that you can really get a good understanding of how the technology actually works, because you have to in order to advise appropriately. And I think that's a really cool part of the practice. And so now going to Shannon, so Charles Hamilton Houston once said, "A lawyer is either a social engineer or a parasite on society." As a Howard alum, what does it mean to be a social engineer in the context of your practice as a data privacy attorney, especially given all of the ethical implications?